Okay, let's begin. Welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. In the trial of Hashim Thaçi, Kadri Veseli, Recep Salimi, and Jakub Krasniqi, on the 11th of October, the trial panel approved proposed redactions to the transcripts of 4 protected witness testimonies, which will allow for new public versions of the transcripts to be released with fewer redactions. This was done in the interest of guaranteeing to the greatest possible extent the publicity of the proceedings and as part of the ongoing effort by the court to make as much material as possible public while still ensuring the protection of witnesses and of victims. On the 11th of October, the registrar notified the panel that Mr. Peter McCloskey's appointment as co-counsel to Hashim Thaçi had been terminated following a request from Mr. Thaçi's lead counsel to terminate Mr. McCloskey's contract as counsel and to appoint him as a consultant instead. Counsel informed the defense office that this change would not adversely affect the interests of Mr. Thaçi or the duration of the proceedings. In the same case, on the 11th of October, the trial panel rejected a defense request to appeal an earlier decision admitting into evidence 3 statements by a witness who testified in court on the 28th and the 29th of August 2024. In their decision, the judges explained that they found the statements to be prima facie relevant, authentic, probative, and not prejudicial. The trial panel also stressed that the judges will take factors such as the statement's claimed inaccuracy into proper account when assessing the weight to be given to the statements in light of the totality of the evidence. On the same day, the trial panel granted a prosecution request for a witness to testify via video conference, noting the absence of any objection by the defense and finding that the witness's health situation justifies his video conference testimony. The trial panel also considered that receiving the witness's testimony via video conference might help to expedite the proceedings. On the 14th of October, the trial panel in the same case denied a defense request to appeal a decision related to the admission into evidence of a document, explaining the reasons for its admission. On the same day, and in separate decisions, the trial panel extended the detention of Hashim Thaçi and of Kadri Veseli. For both of the accused, the judges found that the risk that they will obstruct proceedings and/or commit further crimes against witnesses who have provided or could provide evidence in the case continues to exist. In the decision on Mr. Thaçi's detention, the trial panel also recalled its previous findings that it appears that Mr. Thaçi provided unprivileged visitors with information elicited during the testimony of protected witnesses, and that the record suggests that he passed on to an unprivileged visitor instructions pertaining to a future SPO witness regarding the form and the content of the witness's upcoming testimony. In the same case, on the 15th of October, the trial panel decided on prosecution requests related to 5 witness testimonies and associated exhibits. For 3 of these witnesses, the prosecution had proposed that their testimony be admitted in writing and that they appear in court for cross-examination pursuant to Rule 154. The defense did not object to the admission of their testimonies under this rule, but did object to certain proposed exhibits. In their decision, the judges admitted some of these exhibits and rejected others, explaining their reasoning in each case. For 2 other witnesses, the prosecution requested that their testimony be submitted only in writing pursuant to Rule 153, while the defense argued that these witnesses should appear in court for questioning. For one of the witnesses, the judges found that their testimony can be admitted under Rule 153 because it is largely cumulative and is corroborated by other witnesses whom the defense will also be able to cross-examine, and because it does not relate to the alleged acts and conduct of the accused. For the other witness, the trial panel denied the prosecution's request that this witness statement be admitted into evidence, finding that the defense should have the opportunity to test the credibility of the witness and the reliability of their evidence, and that denying the defense this opportunity could cause prejudice. The next scheduled trial hearing in the Thatchi et al. Case is next Monday, the 21st of October at 1300. Hearings are also scheduled on Tuesday, Wednesday, and Thursday of next week, starting at 9 a.m. on those days. In the Pietrashala case, a public redacted version of the defense's revised notice of appeal is now available on the KSC website, setting forth the defense's grounds for appeal. The original notice of appeal was filed confidentially on the 2nd of September. On Friday, the 11th of October, due to compelling humanitarian grounds, the trial panel in the Yannuzi et al. Case instructed the registry to manage a custodial visit to Kosovo for Hajishala to meet immediate family. As reported last Thursday, the registry also managed a custodial visit to Kosovo for Jakub Krasniqi to meet immediate family, as instructed by the trial panel, based on compelling humanitarian grounds. During both custodial visits, the accused remained in detention and in the custody of the specialist chambers. ULEX and Kosovo police supported the Kosovo specialist chambers. In the Yannuzi et al. Case, the Supreme Court panel yesterday rejected Hajishala's request for reconsideration of its decision on Mr. Shala's request for protection of legality concerning his detention. In September, the Supreme Court panel had concluded that there was no substantial violation of the procedures on the part of the pretrial judge who initially ordered the accused's continued detention, or by the appeals panel that upheld the decision.